This podcast may contain disturbing content for some listeners. It's intended for mature audiences. Listener discretion is advised.
Okay, so we're back with another holiday episode. We have a missing person here. He goes in the name as March 2nd of 2020. And then his NamUs number, with that in mind, is MP65833. His name is Roy Andrew Guyton, Guyton. He's a white male who was 46 years old when he went missing on December 25th of 1992. His nickname is R.A. It says that he was reported missing after he wasn't seen in the days after Christmas Day 1992 by his family. All of his belongings, pets, and items were inside of his residence undisturbed. He's between 5'7" and 5'11" for his height, between 190 and 200 pounds. He had black hair and gray eyes. He goes missing out of Gordon County, Georgia, from a little place called Ranger. If he were alive today, he would be 77 years old. I did not find a lot on Mr. Roy, but I did find a couple references to him. Now, among those references, we have, and I guess this happens periodically, the Gordon County Sheriff's Office on February 6, 2020, they put up a little post, and it said, the Gordon County Sheriff's Office routinely investigates reports of missing persons. Fortunately, most such cases are resolved rapidly and successfully with a missing person located safely. As of today, on February 6, 2020, the Sheriff's Office has 4 open missing persons investigations wherein the person has not been located. For example, the Sheriff's Office received 83 reports or calls for service regarding missing persons cases in 2019. 82 of those reports were cleared. Many times, the person is located before first responders even arrive. The 4 open cases date from 1993 to 2019. Our most recent case sadly ended with the discovery of a missing person's body. In addition to an open 1993 case, and that's Roy Guyton's case, he goes missing at the end of 1992 on Christmas, and it's opened in 1993. There is one from 2008, that's Stephanie R. Davis, one from 2016, Michelle Lynn Gibson, and one from 2019, Rebecca S. Adler. None of these cases are connected, and there's no reason to believe that any of these persons even knew one another. There's no evidence of foul play in these cases. None of these persons were reported missing from a truck stop. These cases are still active, and the Sheriff's Office is, like all other agencies, audited annually by the GBI to ensure that missing persons cases remain open and active. It is our understanding that Kieslyn Noel Roberts, age 20, and then an address, was reported missing on January 20th, 2020. On January 18th, deputies responded to a 911 call at a Flying J truck stop in Resaca concerning a suspicious female person. Upon arrival, the deputies learned that the suspicious female had fled the scene, but they did recover a bag containing Miss Roberts' identification in a restricted employee-only area of the business. Miss Roberts' automobile was found at the truck stop in Ruska by a family member. However, Gordon County Sheriff's Office was not made aware of this information until January 29th. The Gordon County Sheriff's Office is coordinating with the Murray County Sheriff's Office in the furtherance of Mrs. Roberts' case. Detectives have learned there is an outstanding warrant for Miss Roberts' arrest on file with the Whitfield County Sheriff's Office for the offensive violation of probation issued on January 17, 2020 from Whitfield County Superior Court. Investigating officers from both jurisdictions are working to locate Miss Roberts safely. There is no evidence at this time of any connection between Mrs. Roberts and Caleb Nathaniel Smith, age 21, who was reported missing at the Flying J on January the 16th, whose body was found near Sugar Valley on February 2nd, 2020. There is no evidence that these people are acquainted or that their cases are connected. The investigation into these matters are ongoing, and any new pertinent information will be released to the public in a timely fashion. If anyone has any information regarding any of these cases, contact the Gordon County Sheriff's Office, and they list their phone number there. I only mentioned this because I thought it was a very interesting post that's sort of being reposted from the Gordon County Sheriff's Office. And just generally speaking, there's a lot to unpack there in how they're handling things. And they point out that like they would have 83 cases, for instance, in 2019, 82 of those are cleared.
Right, which is actually pretty common.
It's kind of on par with what we come to expect from these cases, I would say.
Right, and eventually, all of them will be cleared. And then as you go through, as more time passes, you will get to intervals where years will go by and like the cases will all be cleared. And then you'll have one or two that are still open, right?
Yeah.
But for the most part, that was was that on social media or just like on their website or?
That was their Facebook page.
Okay, and so they must be. It seems like they're answering a lot of unspoken questions. Did that kind of sound? I mean, like they're getting hints or tips that they don't need or something.
I think they're. I don't think they're unspoken questions. I think they're answering a lot of questions that are being asked of them or questions that are being applied to their work.
I mean, unspoken in the sense that like they're not right there, like at an FAQ.
Yeah, I would tend to agree with what you're saying.
Right. They're addressing things that I guess have come up.
Yeah, it definitely seems like that. It seems like they're trying to figure out a way to blanket answer a bunch of stuff.
Right. So Roy Andrew Guyton, is that how you say it?
Guyton, yeah.
Okay, so he was last seen in Ranger, which was in Gordon County, Georgia. From what I found, Ranger has a population as of 2010 of 131 people.
It's very small.
Right. And so that was up from 85 10 years earlier in 2000. I don't know what the latest is. And somebody was nice enough to look it up, and it appears that Roy had been incarcerated for burglary, but that had happened in 1971.
Yeah, I wasn't 100% sure if that was him.
Well, let's see. 1971, this person was 25. And in 1992, this person was 26. So the age adds up. And because there's only, in 2000, there were 85 people that lived in that town, right? Oh, but this is the whole county. I didn't get that information. I kind of, made a connection there because it seemed like such a small place. It would be unlikely there'd be another guy named that there because his name was Roy A. Guyton, and the physical description that's available matched.
Okay. Well, I can buy that. I don't have a lot of extra information on him. He is not mentioned in a lot of places. I found an obituary for Roy Guyton in Georgia in 2019. The 2019 obituary I found said that he would be 79 years old. So if you run a little math on that, what do you get? If he would have been 79, so there's a Roy Guyton in Georgia that would have been 79 in 2019.
Mm-hmm.
It's
So
the
29,
wrong math, but it's the same guy. So I don't know what you want to do with that math.
29 minus 79, 1940.
Right. As opposed to the gentleman that we're talking about, he'd be 77 today. So there's another Roy Guyton that has a similar age range who passes away in 2019 is what I'm getting at. And so the ages are slightly different. And I wondered if this was not a case of someone walking away. So
Well, he left his pets behind.
I know.
From that, the next thing I would typically do if we were doing more than just, mentioning these guys because they went missing on Christmas, I'd like to see what the weather was like.
Oh, you think this
Because,
might be something? Okay.
well, his residence appeared undisturbed. All of his belongings were still there. His pets were still there. And so, I mean, I guess you could be like so despondent that you don't make arrangements for your animals, but that doesn't really seem like something somebody leaving on purpose would do.
Okay.
Do you think?
No, I mean not necessarily.
Actually, most of the time, though, pets are sometimes what keep people that would otherwise be suicidal alive, right?
Yeah.
I'm just saying that like they give somebody purpose, and I think it's possible if it was cold or snowing or something, right?
It was in the 40s. There was a little bit of rain. For the most part, the day, December 25th, 1992, and the day after are very similar. It was a little windy. The high for the day was 43 degrees where he lived, and there was less than half an inch of rainfall.
Okay, and then going on through, is there I don't know when he was reported missing, but like just like through January of 93, was there any snow or anything?
No snow in December, and then no snow in January either. A little more rain in January.
Okay, and so
Not much.
it's we don't have the information that like, oh, he frequently went out on walks, right? We don't know what his pets were. Like, seems like if you went on walks, you'd take your dogs with you, things like that we just don't have the information. I always picture anybody that lives alone, which from everything I can see here, he did. And he was 46, which isn't old, but it also isn't young, right?
Right.
But I always wonder, like, well, did he have a heart attack, right? Did he go on a walk and have a heart attack or something to that effect? They don't give any mention of a vehicle being missing.
No.
And no, this isn't a case where he was dropped off at his house, right? He was just last seen.
I think he was seen with like either seen or talked to, date of last contact being Christmas Day. And then when he's not seen for a little bit, a missing persons investigation gets opened up.
Right. And so that could be, depending on the situation, if he didn't talk to people but once a week, right? I mean, it could have been, even after he missed them the first week, they might not have reported him missing immediately.
That could definitely be the case here. This is just one of those cases in terms of like him coming in here. He fit some of the criteria that you were looking for. He's a slightly older male. He definitely has lived on his own to some degree. In my opinion, for the most part, if you have pets, you at least have some, even if you don't do great with pets, you have some understanding of the responsibilities of independence.
And it was worth somebody mentioning, right?
Absolutely. I think it is a big deal. And anytime there's dogs, cats, or whatever left behind, I wonder like what really happened to that person. And I know that like a percentage of those cases could be that people genuinely did walk away from things. I think it's less likely.
I think the pets are a really strong indication against it, unless he just knew, that his brother would come take his animals or something like that, which, we don't have that information. But I hope that, because it really boils down to they're either out in the elements somewhere, whether it's purposeful or not, or there's foul play involved, right? when
Yes.
when you're looking at a situation where everything at home is totally normal, right?
Yeah.
That's really all you can go off of there, and which is essentially nothing because there's endless possibilities both ways.
Yeah, I think you can easily get endless possibilities out of some of the cases like this. You know, when I look at these, I often wonder, do the cops have the same idea that you had? Like, uh, they don't take as much information down because they expect the guy's going to show back up, and then they're behind the eight ball by the time they realize it's actually a missing persons case.
Right. And I think that is the case, especially like the early 90s. True crime, I mean, we had like America's Most Wanted and like some unsolved mysteries, but for the most part, like true crime had not exploded yet, right? I feel like missing persons cases were taken less seriously. And actually, I don't feel that way. I'm sure of it, right? It was always the understanding that somebody would come back initially, at least, unless there was like a pool of blood, right? The
Yeah.
last place that they were. And so if you take that into consideration for the time period, and then you go, this is a 46-year-old man in Georgia, I feel like, he was probably not considered to be. I would doubt very seriously, even today, if they had considered him to have possibly been a victim of anything.
I definitely think it would have, if we give them the benefit of the doubt and we say, yes, they eventually figured out this was probably a crime. Again, I stand by the statement. It's too late.
Right.
The evidence wasn't collected. We wandered this direction.
And, and so you have to think that through. The house isn't disturbed. And, I feel like one way a middle-aged man can be victimized would be with a firearm, right?
Yep.
Because that will stop anybody in their tracks. But usually there's evidence of that, right? Or evidence of like how they ended up where they got for a firearm to be used or whatever, right? Or somebody saw something. And I do think that that in between, especially now that we're in 2023, right? 31 years later. I mean, if the investigators that took the missing persons report knew that in, 31 years, this is still not going to be solved, they probably would have paid a whole lot more attention, right?
Or they would have swept the whole thing under the rug so nobody knew they did it. One or the other.
Nobody knew they did what?
Exactly.
No, wait, what do you mean though?
Like if they bungled it, right? And you're saying,
Oh, I see what you're saying. I don't think that they're doing it out of like callousness and not believing that, somebody is genuinely a victim of something. I feel like they're going, this 46-year-old man can take care of himself and we got other things to deal with.
I think what you just said sort of sums up what happened here.
Well, sure. And then like as time goes by, sure, they probably realize, well, that's not normal, right? But as like you said, it's too late, right?
Correct.
And so anything in the meantime is just lost. And now it's sort of at the point where it's like, well, I mean, what can be done? Well, not a whole lot, right?
Right.
And beyond, hoping he's found at some point, who knows? I sometimes wonder, because every single missing person case in Namath, it's either somebody that ran away, like, and that means like usually a child, but somebody that started a new life, somebody that had foul play involved, right?
Yeah.
Or somebody that committed suicide, right? And I guess Occasionally there's accidental things too, like cars. A lot of people in cars are, they've had accidents and they're still in their car. The car just can't be seen. And so that's not really foul play. That's just an accident. And so all of them get divided into just these like few piles, right?
Yep.
And then you've got some crossover ones that you wonder about. And I'd like to know one day, like, okay, well, how many of these people really are just, they fell off the bottom of a cliff. I mean, they fell off the top of a cliff and they're now resting at the bottom of the cliff, right? Like the earlier case we talked about, right?
Yes. Yep.
And that, who in a million years would have thought that was the case? Nobody, right? And so it's just, it's fascinating to me that this poor guy is still unaccounted for.
Yeah, it is. And he is a Christmas missing person. This is Roy Guyton. You can look him up if you know anything about him. There are several people that are, it appears they are actively looking for Roy. Primarily, the Georgia Bureau of Investigation has an open 1993 case file on him. With Adam Jones as a special agent down there, and Melissa Pope is handling the case for NamUs. So you can easily go to NamUs.gov and just look up 65833, and you'll see the name Roy Andrew Guyton or R.A. Guyton, and you could contact him that way if you have information related to his case. Now, I have an exoneration for today that is it's a weird one. How much did you read into this one? Just the basics, or I pulled all the court documents. That's why I was asking.
For Mary Reed?
Yeah.
I have the basic story.
Okay. So this is a Westchester County, New York case from 1972. That's when the crime occurred. Now, the conviction occurs in 1973. The exoneration occurs in 1976. The sentence was 4 to 15 years. We don't know a lot about the convicted person in this case. She has a pretty generic name. I have a lot of court files that I've read about her, but I don't know her age, her race. I just know that she's a woman and her name is Mary Reed. Now, the way that this goes, it's pretty bizarre, and we've talked about cases like this before, where someone is convicted of a crime where a crime likely did not occur at all. This is a particularly interesting one. The summary of this, it comes from the National Registry of Exonerations, and Kate Fontaine put it together. It's sort of a simple summary to start out with, so I'm just going to read like a couple paragraphs here, and we'll talk about that. Mary Reed was convicted of manslaughter following a 1972 shooting in a bar in Mount Vernon, New York. In 1985, her conviction was overturned, and she was awarded compensation for imprisonment and unjust conviction, only to later have the compensation revoked. According to the sole witness, a barmaid named Cloretta Mitchell Booker, a man approached Mary Reed with a razor in his hand in a Mount Vernon, New York bar on the night of January 7th, 1972. Booker alleged that Reed shot this man, John Banks, to death. The authorities arrested Reed based on a rental receipt with her name on it left in the bar, an identification made by Booker. One of the things you're going to notice about this as we talk about it is a lot of these dates and stuff don't make a whole lot of sense. They don't even line up with the court records. This is meaning this particular exonerations entry. Reed claimed that she had amnesia on the night in question. So that's Mary Reed saying, I've got amnesia. I have no memory of what happened that night. In February of 1972, she gets indicted for manslaughter and possession of a weapon. With Cloretta Booker's testimony, it provided the most substantive evidence in the case against Mary Reed. So the case goes to trial in April of 1973. The prosecution successfully relied on Booker's testimony regarding Reed as the shooter, but then sought to undermine her credibility regarding her statement that Banks had approached Reed with a razor, which suggested Reed had been acting in self-defense. The jury convicted Reed of first-degree manslaughter and felony possession of a weapon. Her conviction was based on Booker's testimony and the rent receipt, despite the fact that no one else from the bar saw Reed there that night and there was no physical evidence connecting Reed to the crime. She was sentenced to an indeterminate term of 4 to 15 years, and in 1974, that conviction was affirmed. On October 14, 1975, Mary Reed was paroled after serving 3 years in prison. The following year, her conviction was reversed by the Court of Appeals, and her indictment was dismissed in 1976 based on a lack of evidence connecting Reed to the crime. Part of the decision for the reversal rested on the refusal of the original trial court to allow a medical expert to testify on behalf of Mary Reed regarding her history of amnesia stemming from a 1965 car accident and her amnesia on the night of the crime. The Court of Appeals also found that the prosecution had failed to prove guilt beyond a reasonable doubt because it had not produced one single witness other than Booker who saw Reed in the bar. In 1984, the state of New York passed the Unjust Conviction and Imprisonment Act, which entitled citizens wrongly convicted and or imprisoned to compensation for their hardships. Reed filed a claim under this new act in 1985, stating she deserved compensation for her time in prison. On December 12, 1985, the court determined that Reed was unjustly convicted and imprisoned and found the state liable. On August 10, 1987, the Supreme Court of New York affirmed this finding. And finally, on June 21st of 1980, Reed was awarded $450,000 in damages. However, on March 21st of 1991, Reed's case went before the New York Court of Appeals with the state's claim that no definite, clear, or convincing proof existed that Reed did not commit any of the crimes for which she had been convicted, and therefore she was not entitled to compensation. On May 7, 1991, Reed lost her awarded compensation. The court stated that a reversal of the conviction did not mean actual innocence. Reed was never compensated. What do you think of that case?
I think that it's pretty random. And honestly, my main question was the sole witness, Claretta Booker, indicating that John Banks approached Mary Reed with a razor in his hand.
Mm-hmm.
I immediately was like, why wasn't this self-defense?
Well, it's interesting that you should say that. I snagged the Court of Appeals of the state of New York. I snagged all of it. I have so many court documents in this case. But I got the July 6th opinion from 1976.
Okay.
All right. So I wanted to run this by you, and I'm going to read it in chunks. And I want to see if you see this differently. Again, so this is submitted April 30th, 1976, and it's decided on July 6th, 1976. There's several people involved from the appellate division itself. So we have Robert McGooey he's the appellate's attorney. And then we have Carl Vergari, district attorney. He has James Rose representing the district attorney's office here. And this is the opinion on that, but there are other court documents. This is just where I sort of landed and I stuck here. In the early morning hours, so I'm going to read the sort of facts and the procedural history in chunks here, but I'm not going to read you the whole document. I just want to read you this portion and see if it sparks an opinion for you.
Okay.
In the early morning hours of January 8th, 1972, John Banks was found dead in the Cloud 9 bar with a single bullet wound in his chest. The angle of the bullet was slightly downward. He had a blood alcohol reading of 0.29, indicating that the deceased person had been highly intoxicated. Banks's body had been found a few feet from the serving bar, so like the big bar where the bartenders stand behind it. And from his pocket, the police recovered a straight razor that was wrapped in dollar bills. There was, however, some disagreement between two of the officers who testified as whether the razor had been found in Banks' pants pocket or that of his jacket. The testimony provided a description of the Cloud 9 as having limited exits, locked doors, and a guard dog. making exit by any other than the front door difficult, if not impossible. So this building's set up like a funnel. You go in the front door, you go out the front door. That's really all you can do. In the backyard of the Cloud 9, they find a 25 caliber pistol, approximately 15 feet from the rear of the premises. The only footprints in that vicinity that they can see are those of the officer who recovered this weapon. Once it was found, the pistol was carried suspended on a pen by the officer to his captain, the latter of whom took care of removing the ammunition, but took no care to preserve possible fingerprints. Were it not for the testimony of the barmaid on duty, Claretta Mitchell Booker, then there would have been no evidence connecting Mary Reed with the shooting. In fact, no evidence connected her with the premises in which the shooting occurred, except for a pocketbook, the contents of which included a rent receipt in her name. So it was found open upon a tabletop in the bar's kitchen. All right, so two things connecting Mary Reed to this situation are Claretta says she was there. She's the barmaid behind the counter that night. And Mary Reed, her name is on a rental receipt that is inside of a pocketbook that is sitting in the bar's little kitchen on a tabletop. Does that make sense?
Yes. Mm-hmm.
Okay. So Claretta Booker, when called as a witness by the People, she describes the events at the Cloud 9 bar on the evening in question. She testified that at 9 o'clock she came on duty and that sometime thereafter Banks entered. Later, Banks, who had seated himself near the middle of the serving bar, moved closer to the appellate. And so that's going to be Mary Reed. She's seated at the far end of the bar. The witness says she could hear Banks cussing and subsequently overheard part of a conversation between Banks and the appellate where Banks said, "I will give you my own mess and you won't hurt me." I don't know what that means, but that's what he said. To that, the appellate responded that she was not bothering Banks. The witness testified that she suggested appellate go downstairs where Banks would not bother her. And after finishing her beer, appellate got up and, taking her belongings, started to walk to the rear of the premises, away from the front door and out of the witness's view. The deceased also got up, razor in hand, and followed the appellate. So this guy gets up and follows Mary Reed out towards the back of this area. The appellant was heard to say, "Don't cut me." And Banks took another step toward the appellant, and the witness heard a shot. Banks stepped back against the serving bar, razor still in the hand, blood coming from his mouth. And after falling to the floor, the razor remained beside him, still opened. The witness testified that after the shooting, she saw the point of the gun in Mary Reed's hand, and that she and another barmaid, Evelyn Crawford, placed their hands upon those of Mary Reed, the latter saying, "He was going to cut me." After the incident, Mary Reed left the Cloud 9 by the front door. Apparently failing to give a detailed description of what occurred as she had in a previous written statement, the prosecution requested that the witness be permitted to refresh her recollection by using such statement. So she makes a statement that night, and the police write it down. But when she gets on the stand, she's not really remembering it the same way. So the prosecution arranges for her to use her previous statement to give testimony. Do you follow all that?
I do. That's kind of odd.
It's odd. It's depending on the witness. It's not as odd as you might think.
Well, a lot of times investigators will refer back to their notes.
Yeah, their notes or reports they've submitted or narratives they've submitted, they're frequently made available to them. Yes.
Right. But for like an eyewitness to use notes, I find it odd, but I guess maybe it does happen. But
well, so during the course of this testimony, and for the specific reason that what she is testifying to is wildly different from that of the statement, the prosecution requested that the witness be declared hostile. And so the reason that they're doing this, are you familiar with like how that gets declared in terms of like what the judge is looking for there?
For a hostile witness, it's when somebody is like specifically testifying the opposite way they expect.
Yeah. So when a witness at trial whose testimony is untruthful or appears to be contrary to the legal position of whoever called them, they can be treated as a hostile witness. Either, I think it's only under direct examination. They can ask questions that might seem to be more cross examination. So there, you can call them a hostile witness or an adverse party or an unfavorable witness. Generally speaking, what it allows to happen is that leading questions can be used to suggest the answer, to get the witness to go down a truthful path, or
During direct testimony, right?
during direct testimony, or to challenge the witness's testimony. Leading questions are generally only allowed during a cross examination. So if you hear leading the witness, that is typically somebody's direct testimony. But if they're declared a hostile witness, meaning the prosecution can't get, in this instance, what they want out of Ms. Booker, and they're declared hostile, the idea is they're going to ask leading questions, but they have to do it based on something. In this instance, it's going to be based on the fact that her testimony she's given in the court in front of those who are going to decide this case, the judge, the jury, doesn't match the statement she gave to police that led to these charges in the first place. All right. Is that enough information about hostile witnesses, or do you want me to?
I think that that's enough.
Okay.
Basically,
So,
they expected her to say one thing and she was not going along with it.
right. So the court, or the judge in this sense, he grants these requests. He allows the prosecutor to lead the witness by declaring her hostile, and also allows the judge allows the prosecutor to give Booker her statement. By the use of these leading questions, the jury learned that the witness in her statement had described Mary's first words after the shooting and after the witness took hold of her hands as "turn me loose or I will shoot." So that's an antagonistic move on the part of Mary Reed. Basically, they're interpreting it as Claretta Booker said that Mary Reed threatened an innocent person in the bar who was trying to get her hands on her gun. By way of leading questions, the witness was asked if she had told one of the investigating officers on the night of the shooting that she suddenly heard a shot and saw Banks fall backward off the stool. To this question, the witness's response was a definitive no. So while Claretta Booker's testimony implicates Mary Reed, it's also exculpatory, for it provides a description of circumstances constituting a defensive justification. Namely, that Mary Reed, unable to escape Banks advancing at her and brandishing a razor, protected herself by firing a fatal shot in self-defense. So does that answer your, the primary question there?
I mean, I guess it doesn't really answer why it wasn't considered self-defense, really, does it?
Well, no, we're going to keep going. I'm just saying, but that's what you expected, is that it would be that type of, the defense is like it was a justified shooting.
I can't imagine a situation where an eyewitness would indicate a defendant had been accosted by a man with a razor and that it would be anything but self-defense. But, I mean, that's not what happened, so it's fine.
No, it didn't happen. So the way that this goes down is it's weird for a couple of reasons, and the court touches on that here. So by jury verdict, Mary Reed was convicted of the crimes of manslaughter in the first degree and possession of a weapon, dangerous instrument, or appliance as a felony. On appeal, in support of the conviction, the people are arguing that the physical evidence presented contradicted the barmaid's testimonial evidence as to the manner of death, and that while their witness was credible when she testified that Mary Reed shot Banks, her testimony as to the manner in which the shooting occurred was contradicted by the physical evidence, and thus their witness was not to be believed. So they're trying to have it both ways. They're saying that Booker's saying that Banks brandishes a razor, and the razor is found in his pocket, whether it's his jacket pocket or his pants pocket, it doesn't matter. They want their witness to both be credible and to be wrong at the same time.
Right. And typically that doesn't really work out, right?
In most cases, it wouldn't. But in this case, it kind of weirdly works to the state's favor, even though she is ultimately exonerated.
In the testimony, and I'm not sure if it was her state. I think it was when she was talking before she was declared hostile and forced to read her initial statement. It's my understanding from everything that it was the rent receipt in the purse that ultimately was the connection, right? Because it had her name on it, I guess.
Yeah, there was a Mary Reed written on the rent receipt in the open purse on the tabletop. So the way they presented this in the court documents is she had time to set the purse down, retrieve the gun from it, and turn back on Banks, and that is what connects her, like, to the bar that night, to the crime, and to the fact that she was sort of planning to do something to Banks rather than retreating.
Right. And so, additionally, based on the bartender's testimony, the rent receipt being what, connected her, it's asserted, at least here in the summary write-up, that no one else had seen her at the bar, but it seemed like Claretta Booker's initial testimony at least contradicted that, indicating that the other bartender on duty had assisted her after the incident, right?
Right.
And so she would have seen Mary Reed as well. Or did I misunderstand something?
What do you mean? Like, you're saying that the other, like, you're talking about Evelyn?
Right. Because it says that there was nobody else that said that Mary Reed was at the bar except for Claretta Booker.
Yeah, so there's a bunch of other people that play into the sort of story that the prosecution is setting up and using Claretta Booker to backstop. And ultimately, none of those people say it was that woman kind of situation. There's no circumstantial proof, there's no fingerprints, there's no proof of ownership of the weapon. Nothing else is brought forward to suggest that Mary Reed was in the bar that evening in terms of witnesses. No one else testifies that Mary Reed shot Banks that night, even though there were witnesses. So it's sort of a load of crap.
Well, I was just curious because, so was it that nobody saw her shoot him or that nobody saw her at all?
From the witnesses the prosecution presented, neither thing was brought up.
Okay.
Nobody else identified her as being in the bar that night. And I'm not saying that no one saw her. I'm saying no one who testified to the fact that she was in the bar that night. And in terms of her shooting or not shooting him, other than Claretta Booker, no one testified to any kind of like witnessing the shooting or witnessing something that tied into the shooting and Mary Reed.
Okay. And besides Claretta Booker indicating Evelyn's situation, she's not mentioned in the recount in the appellate document, right?
Claretta Booker is mentioned in here.
Evelyn, the other one, the other bartender.
No, they point out the fact. So in the appellate documents, they point out the fact that Evelyn Crawford, she features in Claretta Booker's story and in the prosecution's story, but she doesn't get on the stand and say, okay, I saw Mary Reed or Mary Reed shot Banks or anything like that.
Okay, so basically that doesn't come in at all. Correct. I mean, except just through the other testimony. Okay, so, and you also mentioned that there was no independent testimony linking her to the weapon.
Correct. There was no evidence offered in the trial related to fingerprints or a permit or like a serial number being traced or any of those things. Nothing that you would normally do today and in various ways all the way back to the time of this case, there was no identifying effort made on the 25 caliber handgun that
Okay.
linked Mary Reed to the gun.
Okay. And then I guess the so I get confused, but I guess the initial court, they were the ones who said they disallowed the medical testimony, right?
Yeah, that's the next thing that happens.
Okay.
Yeah. Okay, so all right. They mentioned this other case, and I'm gonna just blurb it out here so that you can hear it. It's People versus Ledwin. So in People versus Ledwin, the defendants in that case, Joseph and Eddie Ledwin, they were indicted for murder. The murder they were indicted for was Annie's former husband. His dead body had been found suspended by the neck with a rope from the cross piece over the vault line in the water closet of his home. So basically, he's in the bathroom or hot water closet, whatever he's got going on here, and over the beam, he's got a rope that's been tied around his neck. While suicide had originally been found to have been the cause of death, there was an indictment for murder that followed. The testimony of the son of the deceased and Annie provided the only direct proof in the case that the death was anything other than suicide. The trial judge correctly characterized the son's testimony as involved in, quote, hopeless contradictions. He left it to the jury to find whether, on the whole, such testimony implicating the defendants was worthy of belief. The Court of Appeals, in reversing the conviction, stated that guilt in such a case cannot be established beyond a reasonable doubt by the testimony of such a witness who is evidently either from moral or mental defects irresponsible. Take all of that for what you want, but the court here, the appeals court here, says the case before us is remarkably similar to the People versus Ledwin. The credibility of the only witness able to testify as to an essential element of the crime and thus supply the only proof of that element is questioned here, not by the defense, not by the court, but by the prosecution. No other witness could be found to testify that Mary Reed was in the bar on that evening or that Mary Reed shot Banks, although there were others in the bar that night, including Evelyn Crawford, the off-duty barmaid, who played a part in Claretta Mitchell Booker's narrative. No circumstantial proof, no fingerprints, no proof of ownership of the weapon were presented to add credence to what in all other respects, we are told, by the prosecution, is an unbelievable story. So this is the cherry picking I was talking about. The burden was upon the people to prove guilt beyond a reasonable doubt and to disprove the justification defense by like degree. In this case, in the process of attempting to do the latter, the people failed to accomplish the former. Accordingly, there must be a reversal and a dismissal of the indictment. While not determinative here for us, it is quite significant that Mary Reed, though a genuine victim of amnesia, was not permitted to put that fact before the jury. Appellant's counsel, in his opening statement, indicated that by cross-examination of prosecution witnesses, appellant would present a defense of self-defense, and her only offer of proof would be psychiatric medical proof to show that the defendant is suffering from an amnesia, a true lack of memory of the entire incident. Dr. Eva Rado, chief of forensic psychiatry at Grasslands Hospital, was called to the stand as the only defense witness, but was not permitted to testify to her examination of the appellant's condition, or to the appellant's medical history, which it appears included a history of amnesia predating the crime, stemming from a 1965 car accident. The court, accepting the prosecution's objection that a proper foundation had not been laid, would have required the appellant to take the stand before it would have permitted the doctor to continue. This was an error, for no such foundation was necessary. All right, did you follow what it's saying so far there?
Yes, I did. And it's interesting to me that even in, I want to say 1975, is that right?
76.
Is that when it's being appeal? Is that when that opinion is happening?
Yes, well, 76 is this opinion, yeah.
Oh, actually, I'm sorry. No, it was happening during the court case, which is 1973, right?
Correct.
It surprises me that in 1973, a trial court judge would make the presumption that um, in order to get a medical expert on the stand, the defendant would have to forego their Fifth Amendment right to not
Yeah.
incriminate themselves. That's astonishing to me.
Yeah, that's exactly what the court says here. They're in the same place that you are. So basically, they're saying a defendant should not be required to waive her constitutional privilege against self-incrimination in order to place before the jury a fact relevant to her case. Here, the doctor's testimony would have put the fact of the defendant's amnesia into evidence and would have served as an explanation of why the defendant did not take the stand, an explanation the jury never received, and which, in the context of this case, was expected, where the issue was not whether the fact of the defendant's amnesia could be introduced into evidence, but rather whether such amnesia made the defendant an incapacitated person and therefore unfit to proceed the trial. While such trial error, so they're using a different case there, by the way. There's a footnote in here for People versus Franca Banderera, which is an old New York case. I don't know how well that would go if tied in here, but while also trial error of itself, which would have required a reversal in a new trial, here the prosecution failed to prove its case beyond a reasonable doubt as a matter of law, and thus the judgment of conviction should be reversed and the indictment dismissed. So basically, they don't even get to the point. They leave a note in here and basically say, look, this amnesia thing was serious too, but not as serious as this other stuff.
Right. And so I see the court opinion as being heavily skewed, right? I don't know if
The
you do.
court, the appellate court.
The appellate courts, like, yeah, the court that's rendering the opinion that you're reading that overturned the conviction.
Yeah, they're not even remotely interested in the prosecution's case. They destroy it on several grounds here.
Right. And so in cases like this where you've got, they use the precedent that established, some very confusing testimony that was given to a different jury on a different case. It shouldn't have been done, right?
Correct.
And they're essentially saying, based on that finding, like, this witness should not have been presented, right?
Right.
I don't know that I 100% understand, why that was, but I feel like this is a good example of a jury convicted her, right? Yes, the jury convicted her, right? First degree manslaughter.
Yes.
Okay. And so, the jury having been presented this case from this eyewitness and the way juries absorb things and the way court seems to work for, just the average person going in for jury duty or whatever. I assume once the doctor's testimony was not allowed, that there was no further defense, right? And
Correct.
because of that, I think that having presented this witness who said this is what happened, even though it was shaky and it was, it was weird. The testimony was weird. I think the jury's like, well, nothing contradicted that, so that's what we have to go off of, right?
Pretty much, yeah.
And I think that happens a lot of times, right? And so, it seems like, I don't know how the defense would have done it necessarily, but it seems like there were quite a few other things that could have been, explored with regard to, like the weapon and any other. I think that the defense could have called people from the bar that didn't see this happen, right?
Yeah.
And none of that occurred, right? But any sort of anything that could have thrown the witness's statement off balance, or she was a hostile witness to begin with, I guess, and then so she was basically cross-examined twice. And I think that could have been confusing as well, right?
I'm sure it would have been confusing when they get. So the prosecution basically brings this woman out and starts asking her questions. And if you think of it in terms of what they were prepared for, was for the witness to give them a recipe for a peanut butter and jelly sandwich. It probably went something like this: state your name, says her name. So, what ingredients do you use for this peanut butter and jelly sandwich? And the lady says, well, bread. And the prosecutor says, do you use anything else? And she said, well, the stuff you put in sandwiches. And the prosecution says, what about anything else? Like, what are some of the things that you would put in sandwiches? And she says, well, bologna and mustard and mayo and lettuce. So the answers she's giving are not steering the prosecution towards the peanut butter and jelly sandwich. So the prosecution wants permission from the judge to say, look, lady, we talked about a peanut butter and jelly sandwich. Are you going to put peanut butter on that? But in order to do that, to ask the question that way, which is leading the witness, the judge has to sign off on it. And he does. He signs off on it because the prosecution first attempts to hand the lady a piece of paper that has the peanut butter and jelly sandwich recipe on it, and she looks at it and starts talking about bologna. So,
what do you think the motivation of a witness would be to do that?
I think when she told the story in the first place, it was because she was trying to say that lady didn't do nothing. Like, that lady was like, she was going to get shot, and it scared her so bad that she was going to shoot anybody else that tried to stop what was happening next. So she shot this guy in self-defense, and then we were trying to help her. And I think that's the story she told the police. And the police just wrote it down on a factual basis. And then the prosecution took it all together and went, okay, well, this looks like a first-degree manslaughter to me. Because the mistake, I think, in my opinion, is when the prosecutor decides to charge anything where, and I get it, like the cop basically said, the razor was in his pocket. What they were trying to say was that Banks put the razor back in his pocket, so it was away when he was shot. So Mary Reed had been given if it's her, she had been given the opportunity to step away from the heated moment, go back out the front door and leave. But instead, she took the time to go to her purse, set her purse down, take the gun out, shoot this guy that had put away his razor and was about to sit back down. And then she turns around and she knows she's done something wrong and she throws the gun away. But the problem is Booker's story makes no sense. Every version of Booker's story makes no sense.
Right. And so why would she do that?
I don't know. Because she was there and there was a dead person there. I wondered if
she killed him
or covered up for who did.
Because that was my thought. And they don't elaborate further as to whether or not Booker would have been familiar with Mary Reed and her history of amnesia. I feel like Mary Reed was possibly genuinely unable to say whether or not she had done it.
Yeah, and I think I do think that was taken advantage of here. But I'll tell you what, man, I feel like either way, Mary Reed is the victim.
She was absolutely. I mean, a man came at her with a razor. Now, the weird thing to me is I don't see, without there being some sort of underlying motive, I don't understand what the deal with Booker was, right?
Yeah, Mary Reed may not have even been in the bar this night.
At that time, right?
Yeah, that purse and that receipt are never linked in a way that the court accepts.
Well, and to me, the only reason in a case like this, I feel like she needed the police to believe her story at the scene, right? And so she gives all these details, like, she said she was going to cut us, or she was going to shoot us, right? I'm sorry, and so that's her story, like when it happened. But then, like, as time goes by, they go to trial. She realizes, like, oh, I can't do this to this innocent person, right? Except the prosecution didn't allow her to change her story because they brought out her initial statement and they treated her as a hostile witness.
Yeah.
And so to me, I don't see another reason except to possibly be avoiding taking responsibility for what you did or covering up for somebody else, that you would end up in this like strange sort of back and forth, because it's almost like, her back and forth is almost with herself, right?
Yeah.
As far as like what's happening there. And so to me, it seems like that that could have very well played in, but it doesn't go along with sort of how the rest of it goes, right? As far as her being compensated and then uncompensated. And
Yeah, this woman, I hate to say it this way, she sort of stays a victim for quite some time. Like it does not go well for her. I mean, she is eventually exonerated. She's never compensated. She definitely lost quite a bit of time. If you go through the court records, there are numerous instances where they're discussing the fact that she had something wrong with her, and it wasn't just amnesia, but it probably wasn't murderous either. Um,
well, I think that that's pretty clear. I feel like when you respond by shooting somebody that has a razor coming at you, even if he had put it in his pocket, I don't. Now, I mean, this would be like this whole long like argument to have. I personally don't think that a threat would be abated just because a man that had followed you with a razor had put it away. And I would argue that staunchly, right? Um, and so I could see where she would feel the need to protect herself if it was in fact Mary and that is in fact what happened. But the prosecution was so busy trying to get this testimony in that she was going to shoot the people trying to help her, like immediately following the incident. He was trying to say like, oh, this wasn't self-defense. She was like on a rampage, right?
yeah,
And so by doing that, they actually made it sort of seem like they didn't prove the elements required, right? They were too busy trying to get it to be this not a defense, not a self-defense case, that they didn't even prove the manslaughter. And I see that very clearly. But to me, it really makes me wonder, like, what was really happening there.
yeah. I never really get to the bottom of this one. I presented what I know. I read a lot more on it. Like I've read a lot. There were some uh, interlocutory judgments in this case. I read all the way through the final appeal on it. It is heartbreaking from the perspective of Mary Reed, and I pretty much have zero sympathy for Banks that night. I get it. He died. I I do not believe this was a crime. I believe it was a self-defense shooting, unless something were to be brought to me where it was like Booker did it, and maybe Mary Reed witnessed it, and there's something else going on. I could believe something like that. I just can't, Mary Reed is sort of found to be catatonic after this. So I sort of went, okay, maybe she is involved with it, but I don't think in any way, shape, form, or fashion that I think the defense is justification here. It's a self-defense claim that which in and of itself means no crime occurred. It's a justifiable homicide.
Correct. I agree.
That's all I got on this one. You got anything else?
Well, yeah. I thought it was interesting that so Reed was awarded $450,000 in damages by the
Yes.
state. And that was because in 1984, the state of New York passed the Unjust Conviction and Imprisonment Act, which entitled any citizen that had been wrongly convicted and or imprisoned to compensation for the hardship it caused them. And so Mary Reed filed a claim under the act in 1985. So that would have been about 9 years after her exoneration.
Yes.
She felt she deserved compensation for the time she had spent in prison. And on December 12th, 1985, the court determined that Reed was unjustly convicted and imprisoned and found the state liable. But then on August 10th, 1987, the Supreme Court of New York affirmed the finding. Wait,
Yeah, it goes on for a while longer.
okay, I'm sorry. On August 10th, 1987, the Supreme Court of New York affirmed the finding that Reed was unjustly convicted and imprisoned. And then on July 21st of 1990, so 3 years after the Supreme Court of New York affirmed the finding, Reed was awarded $450,000 in damages. On March 21st, 1991, Reed's case went before the New York Court of Appeals with the state's claim that no definite, clear, convincing proof existed that Reed did not commit any of the crimes for which she had been convicted, and therefore she was not entitled to the compensation. On May 7th, 1991, Reed lost her compensation, and the court stated that a reversal of a conviction did not mean actual innocence, and Mary Reed was never compensated.
Yep.
Is that how it stands to this day?
Yep.
That's interesting to me because it doesn't actually say. See, I don't know. What do you think about that?
I think there's a lot of contradictory arguments being made from before this case even begins.
Well, sure. And I would say that a reversal of a conviction would still be someone who had been wrongly imprisoned,
Yep.
even without clear and convincing evidence of innocence, because you're kind of going the whole opposite direction there, right?
Well, they're saying that different standards apply because under that act, this is compensation civilly for criminal acts that have been overturned. So they're saying that the standards are flip-flopped to preponderance from reasonable doubt. So beyond reasonable doubt is true for criminal cases. But the state is put in an adversarial position where they must just present that instead of 99%, they only have to present 51%. They have to say that, like, the standard is preponderance. There is a possibility she did it, and it's based on this preponderance of the evidence, and there was no other evidence.
Right, except I feel like, I don't know if you're reading off of something there, but...
No, I'm not.
Okay, I feel like the roles are switched there. She would have to prove by the preponderance of the evidence at a 51% mark that she didn't do it.
Except they brought the claim against her claim. So
it
starts out that she needs to say to the 51% mark that they owe her money because she did prison time. And then when it flips, they have to overturn it with 51%. You see what I'm saying? You're paying it.
In the Court of Appeals?
Yeah.
The Court of Appeals would just find if she had shown it or not.
Well, clearly they thought they were supposed to be finding something different. So.
Well, I don't know. I'm just saying, well, my understanding of it. You could be absolutely right. But to me, it's interesting because I don't see... I guess the state court decided, right, that was their standard, and as long as they hold it up or whatever. But to me, I feel like that was wrong. An overturned conviction is a wrongfully imprisoned person. So
yeah,
reworded that.
It's more than wrong. It's like really messed up. And the deeper that you dig into it, it gets more wrong. And that's why I was saying, by the time I got to the 1991 claims, it was disheartening to say the least. It's actually quite terrible. Like, because you have a young lady who defends herself only briefly, one shot, no overkill, of a guy who is identified as coming at her with a razor.
Right.
She spends multiple years in prison, then gets out on parole, and then everything is overturned for her. Except she can't get the compensation from this act. Now, she's never brought up or considered, to be
Guilty.
to be guilty, except in the eyes of the state not wanting to compensate her.
Right. And so that, like the politics of that Compensation Act come into play there. And I understand that. But at the same time, it's two different things that they're talking about there. Like as far as actual innocence versus like a conviction being overturned, a lot of times in the process of getting a conviction overturned, you don't actually get the chance to prove your actual innocence. I mean, that's pretty standard across the board how like criminal procedure works, right? It's more about the state proving guilt or not proving guilt, right? That it would be actually proving your innocence. Our entire criminal justice system, like it at this point, contrary, even if it seems like it's not, like there's nothing based on a defendant proving innocence, right?
Yeah.
And so that's so bizarre to me that they brought that up at that point. But I mean, it is what it is, right?
Yeah, just generally speaking, this case is a little weird. Like
It's a lot weird. It's
at every turn. There never should have been an arrest.
No, there shouldn't have been. And again, there was such a strange beginning with the bartender like stating what she said, and I don't know, I just find it really strange, even given if everything she said was true, it was self-defense. I mean self-defense to the point where it wasn't necessary to bring charges at all, right? I don't see how they're going to not see it that way. But then I think the murky water starts with the witness being weird, and that's not a reflection of the defendant.
Right.
And they misguided that. But that was it. I just wanted to mention that about the compensation, because I thought that was just like one more slap in the face, right? Because
you're totally right. It was horrible that they did that to her.
When our system decides to be broken on a person, right? Which is often, you get like, you get slapped both ways, right? Coming and going. And it is a little bit unbelievable that had a little bit of common sense and logical thinking been applied by players in this, the investigators early on, right?
Yeah.
They could have avoided ruining this woman's life, essentially. Because, I mean, however it panned out eventually, there's no question that this would have ruined her life. I hope she, rebounded and overcame it. But, like, it kind of irritates me anytime I see situations that, and, relying on court documents because they're supposed to be reliable with regard to the facts of the case. There's no question here that this is ridiculous. I'm honestly surprised that the Court of Appeals didn't, say something. But also, I guess they sort of did when they said that the prosecutor was so focused on making it not be a self-defense case that they were unable to prove the elements of the crime.
Yeah.
Right. So I think that they did kind of say that. But to me, if you're the prosecutor going, hey, I need to make sure I'm proving this wasn't a self-defense murder, right? I feel like you've kind of missed the boat there.
I would tend to agree with what you're saying. Like, I don't know why they get in these positions. And sometimes I want to look up these prosecutors and be like, what was going on there at that time?
This is so long ago, though.
Yeah, it is a really long time ago. Had gone on to look up Mary Read, and I don't know for sure that what I'm about to say is accurate, but I'm saying it anyways. If I read it correctly, so I found this situation where there was another felony conviction for the same person.
Oh, really?
Yeah, and I wondered if that's where the weapons charge came from. There was a robbery in the third degree, and she would be 77 years old today, but the date of the birth date on it was May 16th, 1946, and then the date that she was received into um, server sentence was May 7th, 1973. And I couldn't make those dates work, but it was the only Mary Read in 73. Does that make you see what I'm saying there?
Mm-hmm.
And I just could not figure out like how all of that would have gone for that to be her, because that might make more sense as to why they moved so quickly and charged her with manslaughter, is if she also had this robbery conviction. But I don't know that that is the case.
Well, it never came up, right?
No, it doesn't come up. But it's the only Mary Read that's arrested in 1973 now that this record is squashed.
But wait, didn't that's sorry, I got confused. So what year did this happen?
Okay, so Mary Read is involved in a 1972 bar shooting.
1972.
She gets convicted in 1973.
Okay.
There's a record of a non-arrested Mary Read. So there's no arrest for Mary Read in 1973. But there is a record of this woman being received into a New York prison on May 7th, 1973. Follow me there?
Mm-hmm.
So when I went back and looked at this, Mary Read went to trial in April of 1973. And I was thinking maybe this other robbery conviction is also hers. It's the same woman. She's never arrested in 1973, but she suddenly goes to state prison in 1973. That's Mary Read, that was born May 16th, 1946, and is 77 years old today.
And we have no way to know if that's the
No,
one.
I do not. But I was just pointing it out to you because I thought maybe, maybe there's some racism at play here in the 70s. Maybe it's the fact that like she was, already sort of stuck, for a better word. But so the shooting took place in Westchester County. That other Mary Read had a charge in Kings County that like doesn't show up anywhere. And the last thing that happened to her, she's released December 14th, 1973 on parole.
Huh.
So that's why.
I don't think that could be her. Well, I don't know. That gets confusing. But yeah, I would say that if it were her, you were saying stuck. Yeah, when you're stuck, when you have a record, you immediately become a lot easier to target by the police or to present charges against by the prosecutor, or however you want to look at it, right?
Yeah. It gets a lot harder to be innocent until proven guilty.
Yeah, I agree.
That's all I got on this one. Anything else?
No.
Thank you for joining us. We'll see you next time.
We wish you a Merry Christmas. We wish you a Merry Christmas. We wish you a Merry Christmas and a Happy New Year. We wish you a Merry Christmas and a Happy New Year.
This is True Crime XS Christmas.
All right, so I'm going to tell you guys a few things about some of the folks who are helping sponsor our show. Now, Labrati Creations sponsors our show, and you can always use the Crime XS code there. You can also just message them at Labrati Creations, and they will generally do something for the people who come from True Crime XS. They were our very first sponsor. They've done a lot for the show, and that code is Crime XS at LabratiCreations.com. The first new advertisers that we have, and I've selected all of these guys. I've selected all of these advertisers. So the very first one is Cure. Now I'm going to tell you guys about this, about Cure as being one of our sponsors. If you're an athlete, you know that proper hydration is key to peak performance, but plain water can be boring and sports drinks can be filled with artificial ingredients and added sugars. That's why we love Cure. It's a clean and effective way to stay hydrated and perform at your best. I use it late in the day when I switch out of caffeine mode. Specifically, when I hit the pool or I go play tennis with my wife, I use Cure to help me stay hydrated. It helps me recover after a long day. Now, you guys may not know this, but I build things. And right now, I've been building several structures on our property out here. Among those is a new podcast studio space for myself. I do a lot of that work at night and into the wee hours, and I always have some Cure with me to go into my aluminum water bottle. Hydration is not just about filling up my aluminum bottle with water. Cure Hydration is an oral rehydration solution that contains the perfect balance of electrolytes and glucose to help your body absorb water and rehydrate quickly. Whether I'm building things or putting the podcast together or chasing these dogs that you sometimes hear in my studio up and down the trails to get them worn out, Cure Hydration is the way that I choose to go. Cure Hydration is an oral rehydration solution, or an ORS, that contains the perfect balance of electrolytes and glucose to help your body absorb water and to rehydrate quickly. The formula is made with all natural ingredients like coconut water powder and pink Himalayan salt. It's free from artificial flavors, from sweeteners, and preservatives. Cure Hydration is vegan, gluten-free, and non-GMO, making it a great option for anyone with dietary restrictions or preferences. The packets are convenient and easy to use. You just mix them with your water and you drink. They're perfect for on the go. They're perfect for travel. And anytime you need a quick and effective hydration boost, ready to combat dehydration, then you try Cure today and feel the difference for yourself. You can use code TrueCrimeXS for 20% off your order. That's TrueCrimeXS. I have a link that I'm putting in the most recent episode show notes, and True Crime XS will get you 20% off. Our second sponsor for the show today is Laird. Now, Laird has a list of things that they want me to tell you about. They have better ingredients with amazing taste and functional benefits. They have a superfood creamer crafted from the highest quality, all-natural, real food ingredients. All Laird products are sustainably sourced and thoroughly tested to ensure that you're incorporating the cleanest, finest fuel into your routine. They have all natural whole food ingredients, and they contain naturally occurring MCTs made from coconut oil. There's no artificial flavors, there's no colors or additives, and there's no sugar from highly refined corn syrup. They want me to talk about my love of coffee, but the truth is, I don't do much with coffee. But let me tell you someone who does. My wife has to have a cup of coffee every day. Now, I've fallen off recently, but one of the big things that I've done since the beginning of our relationship is she used to go and get a Starbucks every morning. I have substituted that out by always trying to make her coffee. It's not going to be every single day of time from when I met her, but for the most part, almost every day, I make her coffee. I put her creamers together and I make sure that she has a good way to start her day. So with Laird, he started experimenting with his morning ritual almost 2 decades ago. He found that when he started adding fats to his morning cup, like coconut oil, he had amazing energy throughout the rest of his day. He gradually perfected this recipe for an epic cup of fuel, and he began sharing it with his friends in the surf community. I'm an ocean guy, so I saw this item and I was like, okay, we're going to try this one out. Are you ready to feel more energized, more focused, and supported? Go to lairdsuperfood.com and add nourishing plant-based foods to fuel you from sunrise to sunset. And you can use our promo code at checkout to save 15% off your purchase today. Our offer code for this for Laird is going to be True Crime XS. Pretty much everywhere except for Labarde Creations. If you use True Crime XS, that will get you at Laird, it'll get you 15% off. At some of the other places, they'll get you 20% off. I'm going to tell you about two more sponsors today. So the first one is, the third one is Liquid IV. So let's talk about the real reasons that you need to hydrate. Late night TV binging, back-to-back Zoom meetings, going on a walk with your friends. Everyday hydration is not just for high energy athletic endeavors. Liquid IV is the number one powdered hydration brand in America. It's now available in sugar-free. This is years in the making, but Hydration Multiplier Sugar-Free uses a proprietary zero sugar hydration solution with no artificial sweeteners. It's got 3 times the electrolytes of the leading sports drink, but it's also got 8 vitamins and nutrients for everyday wellness. Liquid IV hydrates 2 times faster than water alone. Keep your daily routine exciting with 3 new flavors. They've got white peach, green grape, and lemon lime. I love all of these flavors, but I think that my favorite is probably the green grape. White peach I use as a secondary flavor, and lemon lime I leave here for my kids and my wife. Liquid IV believes that equitable access to clean and abundant water is the foundation of a healthier world. They also partner with leading organizations to fund and foster innovative solutions that help communities protect both their water and their futures. To date, Liquid IV has donated over 39 million servings in 50 plus countries around the world. You can get 20% off when you grab your Liquid IV Hydration Multiplier sugar-free or any other variant at liquidiv.com and use code TrueCrimeXS at checkout. That's 20% off anything you order when you shop Better Hydration today using promo code TrueCrimeXS at liquidiv.com. And the last sponsor I want to tell you about is Zencastr. We are part of Zencastr's creative network. We've been using Zencastr since about midway into our first season. Meg and I experimented with a lot of different ways to put the podcast together. And the truth is, Zencastr was an integral ingredient to us being able to bring you this show. It's so easy. It's now super easy. You can record a podcast with Zencastr. You can log in using your browser and you start recording a high quality podcast right away. You can record studio quality sound and up to 4K video with your guest. You get to feel a sense of zen knowing that Zencastr's multi-layered backups ensure you will always have your recordings in the highest quality, even if the connection is unstable. You sound your best. I mean, if you've ever worried about what you sound like, Zencastr's post-production process makes you sound buttery smooth. It automatically removes those ums and ahs in your recordings. It removes those awkward pauses in conversation too. You can set the right podcast loudness and levels while reducing background noise with a click of a button. That's how you don't hear my dogs every second of every episode. Zencastr is all in one. If you've thought about podcasting before and realized that you need a lot of different tools and services, those days are now over. With Zencastr's all-in-one podcasting platform, you can create your podcast all in one place, and you can distribute to Spotify, Apple, and other major destinations. Just go to zencastr.com/pricing and use my code TrueCrimeXS, and you're going to get 30% off your first month of any Zencastr paid plan. You can also check out the other plans they have available. I want you to have the same easy experiences that I do for all my podcasting and content needs. So zencastr.com/pricing. The offer code is TrueCrimeXS, and it's time for you to share your story today. We are also adding New Era as a sponsor for the show. New Era Cap is a headwear and apparel brand founded in 1920 in Buffalo, New York. Now, I actually have some experience with New Era caps. My dad and I have been through multiple iterations of baseball caps through the years. We collect different styles, different eras, and now my teenager has started his own cap collection and has several new eras as the centerpieces. Our favorite teams may not be the same, but our outfits are all topped with the same new era ball caps. We love the quality and the ability to wear what the players are wearing. Not to mention, New Era is the leading headwear manufacturer with quality licensed products. You can support your favorite college or pro team in style from the official headwear provider for the MLB, NFL, and NBA. You can get a stylish accessory for your everyday ensemble and support True Crime XS. Just shop the official headwear and get 15% off when you go to neweracap.com. That's neweracap.com/truecrimexs. You can also use the code truecrimexs at checkout. That's it. That's all you have to do. And that's 15% off your order using the promo code truecrimexs.